Welcome to Civil Rights and Child Nutrition Programs. The objectives of this presentation are as follows. By the end, you will be able to implement correct civil rights procedures, provide reasonable modifications to accommodate disabilities for program participants, establish a civil rights complaint procedure, and have completed your annual civil rights training. Here are the topics we're covering today: legislation, assurances, public notification, data collection, language assistance, modifications to accommodate disabilities, complaint procedure, civil rights reviews and resolution, training, customer service, and conflict resolution. Let's get started by discussing legislation. Title VI of the Civil Rights Act of 1964 added protections for race, color, and national origin. The Civil Rights Restoration Act of 1987 clarifies the scope of the Civil Rights Act of 1964. Section 504 of the Rehabilitation Act of 1973 and Americans with Disabilities Act of 1990 and the ADA Amendments Act of 2008 put in protections for disability, and the Age Discrimination Act of 1975 added protections for age. Title IX of the Education Amendments of 1972 added protections for sex. There are a variety of civil rights program authorities included throughout regulatory requirements. 7 CFR Parts 15, 15A, and 15B talk about non-discrimination requirements, education, and disability. And for your reference, the next few slides list other regulations that include civil rights program authorities and civil rights regulations. Executive Order 13166 addresses improves access requirements for persons with limited English proficiency, otherwise known as LEP. There's also LEP policy guidance. USDA Department Regulation 4330-2 prohibits discrimination in programs and activities receiving federal funds from the USDA. FNS Instruction 113-1 and FNS Instruction 113-1 Appendix B, School Meals, SFSP, and CACFP, also includes information on civil rights program authorities. 7 CFR Part 16, Equal Opportunity for Religious Organizations, allows religiously funded and affiliated organizations to compete equally for USDA funds. Implementing equal opportunity for religious organizations. This can be accomplished by prohibiting discrimination for or against an organization on the basis of religion, religious belief, or religious character in the administration and distribution of federal funds. Allowing a religious organization that participates in USDA programs to retain its independence and continue to carry out its mission, provided that direct USDA funds do not support any explicitly religious activities such as worship, religious instruction, or proselytization. Clarifying that faith-based organizations can use space in their facilities to provide USDA-funded service without removing religious art, icons, inscriptions, or other religious symbols, and ensuring that no organization that receives direct federal funds can discriminate against a program beneficiary or prospective beneficiary on the basis of religious belief or religion. What is discrimination? It's different treatment which makes the distinction of one person or a group of persons from others, either intentionally, by neglect, or by the actions or lack of actions based on a protected class. There are federally protected bases. For federal food and nutrition service programs, FNS, complaints are based on one or more of the 6 federally protected bases: race, color, national origin, age, sex, including gender identity and sexual orientation, and disability. There are also protected classes under Maine state law. This adds protections for a person with regard to religion, ancestry, genetic information. All federal child nutrition programs operating in public school districts in the state of Maine must adopt both federal and state protected classes. Recently, the Bostock memo was released, and this clarified that discrimination on the basis of sex in programs or activities receiving federal financial assistance includes discrimination on the basis of sexual orientation and discrimination on the basis of gender identity. This policy update is consistent with the Supreme Court's decision in Bostock versus Clayton County, 140 S. CT 1731 590 US 2020, and applies to prohibitions against discrimination based on sex in all FNS programs. It updates the federal non-discrimination statement, sex, including gender identity and sexual orientation. An updated and Justice for All poster has been ordered and will be released and provided to our providers once we obtain these posters. This is being recorded in school year 23. Let's talk about civil rights assurances. To qualify for federal financial assistance, the program application must be accompanied by a written assurance that the program or facility will be operated in compliance with the civil rights laws and implementing non-discrimination regulations. A civil rights assurance must be incorporated in all agreements between state and local agencies and their subrecipients. Retailer and vendor agreements must include an assurance of non-discrimination. For example, many SFAs contract with food service management companies. In Maine, we also have a food service management company. The SFA is responsible for ensuring that the food service management company is in compliance with civil rights requirements. FNS Instruction 113-1 Appendix B contains required assurances language. State agencies, local agencies, and other subrecipients must be in compliance with civil rights requirements prior to approval for federal financial assistance. Why are there assurances? These help clarify expectations, eliminate discrimination against applicants, participants, and beneficiaries, prevent future discrimination, and address effects of past discrimination. Next, we'll talk about public notification. All FNS assistance programs must include a public notification system. The purpose is to inform persons of program availability, program rights and responsibilities, the non-discrimination policy, and the procedure for filing a complaint. Program availability. This informs applicants and potentially eligible persons of the availability of the program and the steps necessary for participation. Rights and responsibilities. This informs applicants, participants, and potentially eligible persons of their program rights and responsibilities. The non-discrimination statement. All information materials and sources, including websites used by FNS, state agencies, and other subrecipients, including SFAs, our sponsors, to inform the public about FNS programs must contain a non-discrimination statement. The statement is not required to be included on every page of the program website. At a minimum, the non-discrimination statement or a link to it must be included on the home page of the program information. Complaint information. Advise applicants and participants at the service delivery point of their right to file a complaint, how to file a complaint, and the complaint procedures. Here are the elements of public notification. You have to make program information available to the public upon request, prominently display and Justice for All poster, inform potentially eligible persons, applicants, participants, and grassroots organizations of programs or changes in programs, convey the message of equal opportunity in all photos and other graphics that are used to provide the program or program-related information, provide appropriate information and alternative formats for persons with disabilities and in the appropriate languages for LEP persons, and include the required non-discrimination statements. Here's the Injustice for All poster that we currently physically have. As mentioned before, we are going to be receiving updated versions of this that have the updated federal non-discrimination statement and policy for non-discrimination. This will be distributed to all of our sponsors. This poster must be displayed in a prominent location for all customers to view. The poster itself is the USDA AD-475A. There's a different poster that's used for other federal programs. These posters can be ordered through the Maine DOE at 624-6842. We have ordered more than enough for all of our SFAs and program sponsors. How is the non-discrimination statement used? At a minimum, the full non-discrimination statement should be on vital documents, including but not limited to the application forms, free and reduced price meal benefit application, the meal benefit application cover letter, the notification of approval or denial of meal benefits, and the reminders regarding expiration of previous year eligibility benefits. On verification materials, like the verification notice and verification results letter, on any notice of adverse action forms, on the program home webpage, public information, including program literature, for instance, pamphlets that promote the meal benefit application would need to include the full non-discrimination statement for both the federal non-discrimination statement and the state of Maine. Here's the federal non-discrimination statement. This has been updated to include clarification on non-discrimination of sex, which includes gender identity and sexual orientation. We have the updated version on our Maine Department of Education Civil Rights website. There are translated versions of the non-discrimination statement, NDS statement, available at this link. Here's the Maine non-discrimination statement. It includes additional protections as expressed earlier in this presentation. And it also has different instructions on how to file a complaint of discrimination. As a reminder, if a complaint is made on a Maine class that's not included in the federal protected classes, a complaint must be filed with the Maine Human Rights Commission. There is a short non-discrimination statement that can be used on program menus. With the exception of menus, you must get state agency approval prior to use of the short statement, which is as follows. This institution is an equal opportunity provider. Here's the Spanish version, and we have other languages available on the FNS Civil Rights website. This may be used upon approval from the state agency when the longer statement does not fit. The font size used is no smaller than the font size used in the rest of the publication, and it's required to maintain a file with samples of pamphlets or flyers showing the non-discrimination statement. Let's talk about data collection. Racial and ethnic data collection. The purpose is to determine how effectively FNS programs are reaching potentially eligible persons and beneficiaries. As a means of monitoring civil rights compliance, state agencies shall establish a system for the collection of racial and ethnic data of each person applying for and receiving benefits. Applicants shall be assured that the information is required for and used for statistical purposes only and has no effect on eligibility criteria. The data should be collected at the point of application or may be collected at the time of student enrollment by the school. Data will be used to determine how effectively FNS programs are reaching potentially eligible persons and beneficiaries, identifying areas where additional outreach is needed, and to assist in the selection of location for compliance reviews and complete reports as required. State agencies, local agencies, and other subrecipients are required to obtain data by race and ethnic category on potentially eligible populations, applicants, and participants in their program service area. Systems for collecting actual racial and ethnic data must be established and maintained for all programs. Applicants shall be assured that the information is required for and used for statistical purposes only and has no effect on eligibility criteria, and children are not to be surveyed. It's a 2-question format. Number 1 is the question based on ethnicity, Hispanic or Latino, not Hispanic or Latino. Question 2 is the race question. One or more of the following can be selected: American Indian or Alaskan Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, and white. Here are population data sources, including the US Census data and the American Community Survey data source. Now we're going to talk about language assistance. Limited English Proficiency, LEP. Individuals who do not speak English as their primary language and who have a limited ability to read, speak, write, or understand English. Federal agencies and recipients must take reasonable steps to ensure meaningful access to their programs and activities by LEP persons. Meaningful access is accomplished by providing reasonable, timely, appropriate, competent, qualified, accurate, effective language services to individuals with LEP when assessing programs and services. You can use a 4-factor analysis to consider in addressing LEP. 1, the number or proportion of LEP persons eligible to be served or likely to be encountered within the area serviced by the recipient. 2, the frequency with which the LEP individual comes into contact with the program. 3, the nature and importance of the program, activity, or service provided by the program. And 4, resources available to the recipient and costs. Translation resources may be needed. There are translated free and reduced meal applications available in a number of foreign languages at the link below. Other program materials may need translation. Foreign language teachers, community organizations, and volunteers may be used, but it's really important to understand that confidential information should not be shared and that there are confidentiality requirements. Interpreter hotlines are another option to consider. Children should not be used to translate program requirements to parents and guardians. Here's additional language assistance resources, including the Migration Policy Institute's National Center on Immigrant Integration Policy, the Department of Justice website for LEP guidance, and Maine DOE has access to a company called Language Line Solutions, and your organizations might have access to Language Line Solutions as well. Let's move on to discuss modifications to accommodate disabilities. Disability discrimination. Sections 504 of the Rehabilitation Act of 1973 and USDA Implementing Regulation 7 CFR Part 15B prohibits discrimination based on disability in programs or activities receiving federal financial assistance. The Americans with Disabilities Act, 28 CFR Part 35, Title II, Subtitle A, prohibits discrimination on the basis of disability in all services, programs, and activities provided to the public by state and local governments. These civil rights laws protect persons with disabilities if they are potential applicants or participants in any FNS-funded programs. Disability discrimination. What is the definition of a disability? A person who has a physical or mental impairment which substantially limits one or more major life activity, has a record of such an impairment, or is regarded as having such an impairment. Major life activity means functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. Functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, cardiovascular, endocrine, and reproductive functions are included based on the ADA Amendments Act of 2008. So it's important to make sure that there's access to our program and that reasonable modifications for meal accommodations are provided. Maine Department of Education has a separate training on meal modifications, so it's important that you are aware of that training and access it. You want to make sure that food service areas are accessible and, if needed, provide auxiliary aids and services. For example, food services aids, adaptive feeding equipment, meal tracking assistance, and other effective methods. As mentioned prior, the ADA Discrimination Act, the Amendments Act of 2008, I should say, puts in protections for the digestive system, which clearly aligns with your jobs of making sure that all have access to healthy meals. You also want to consider the environment and make sure there's an integrated environment. Integration clause in section 504 means that disabled individuals should be accommodated in the least restrictive and most integrated setting possible. In the food allergy context, this most often comes into play where children with food allergies are ostracized in some way during mealtime. Allergy-free tables, such as peanut-free tables, are acceptable as long as they are not also used as punishment tables. Providers must always balance safety with stigma. The severity of the allergy and the age of the child are the primary considerations. Now let's talk about complaints of discrimination. Complaints shall be accepted and forwarded to USDA FNS Regional Office of Civil Rights. The Maine Human Rights Commission must also be notified. Complaints must be filed within 180 days from the alleged act of discrimination. Complaints may be written, verbal, or anonymous. State agencies or subrecipient agencies may develop their own complaint forms, but the use of such forms cannot be a prerequisite for acceptance. A separate civil rights complaint log shall be maintained by the state and subrecipient agency. Confidentiality is extremely important and must be maintained. Here are the types of complaints you might see. Customer service complaint. There has been a breakdown in service and can result from a lack of customer focus, being insensitive, or demonstrating a lack of understanding. A civil rights complaint, discrimination complaint, is characterized by the complainant verbalizing or submitting in writing that they feel they have been treated unfairly or discriminated against due to a protected class basis. Here are the USDA complaint forms. We have links here. Here's links to the English version and the Spanish version. And here's the information for the Maine Human Rights Commission. Now we're going to talk about civil rights reviews. There are three types of compliance reviews: a pre-award compliance review, a routine post-award compliance review, and special compliance reviews. During a post-award routine compliance review, here are the areas of review: assurances, public notification, racial and ethnic data collection and reporting, civil rights complaints, compliance reviews, resolution of non-compliance, civil rights training, disability compliance, limited English proficiency, verification of citizenship or immigration status. Special compliance reviews may be scheduled or unscheduled. They may occur to follow up on previous findings of non-compliance, to investigate reports of non-compliance by other agencies, media, or grassroots organizations, may be specific to an incident or policy, history of statistical underrepresentation of a particular group or groups, and a pattern of complaints of discrimination. Resolution of non-compliance: a factual finding that any civil rights requirement as provided by law, regulation, policy, instruction, or guidelines is not being adhered to by a state agency, subrecipient agency, or a local site. Steps must be taken immediately to obtain voluntary compliance, and a finding's effective date is the date of notice to the reviewed entity. A voluntary resolution agreement is an agreement that recipients are willingly consenting to undertake remedial actions to address identified areas of noncompliance or in violation with applicable civil rights laws and/or regulations. The VRA may be between multiple parties, such as the officials and authority to regulate civil rights law, FNS Civil Rights Division, recipient or subrecipient, state agency or school, and the program participant. Voluntary resolution agreements may be used to close out a civil rights compliance review at the discretion of FNS Civil Rights Division in lieu of issuing a written compliance review report with findings. Here are some common civil rights findings. Not all staff involved in CNP operations having received civil rights training. Incorrect, complete non-discrimination statements on program materials, and the Maine non-discrimination statement missing. You also want to make sure that you have the most recent And Justice for All poster, and as mentioned, a new one is on its way, and we will be sure to make it available for school year 2023. Let's talk about civil rights training. Child nutrition program sponsors, including SFAs, are responsible for annually, based on a calendar year, training all staff involved in any and all aspects of the child nutrition programs, including all food service staff, free and reduced meal application approval staff, teachers responsible for breakfast in the classroom, any program volunteers. New employees must be trained before involvement in child nutrition duties. Training must be documented with dates, names, signatures, and topics covered. Specific subject matter required, but is not limited to public notification systems, collection and use of data, requirements for language assistance, requirements for reasonable accommodation, complaint procedures, civil rights reviews, resolution of noncompliance, customer service, and conflict resolution. There also should be training on complaint procedures. Staff should be able to identify a civil rights complaint if received. They should know what to do if they receive a complaint, and staff must understand that it is a basic right of persons to file a complaint of discrimination. Staff should also understand that there's a difference between complaints at the federal level and complaints based on additional state of Maine identified classes. For those state of Maine, additional protections would go through the Maine Human Rights Commission. For the federally protected bases, complaints of discrimination would go through USDA. Let's talk about customer service. Although people should never be discouraged from filing a complaint of discrimination, sometimes it is more of a program complaint than a civil rights complaint. Good customer service reduces the chances of discrimination. Be courteous and thoughtful. Be patient, listen carefully. Treat all students equally. No separation by protected bases in seating arrangements, serving lines, services and facilities, or eating periods. As noted in the accommodation section, allergy-free tables, such as peanut-free tables, are acceptable as long as they are not also punishment tables. Talk with kids and ask them how their day is going. Encourage them to try new things. Allow children to finish their meal without feeling rushed. Be mindful of how you talk about the food you are serving. Let's move on to talk about conflict resolution. It is possible to avoid a potential civil rights complaint with conflict resolution techniques. Remain calm, ask about the situation. Repeat it back to make sure you understand. Try to help those involved work out their differences. Get help from authority figures if threats or violence is possible. Citizenship or immigration status should never give rise to discrimination. Record retention must also be considered. All records must be kept confidential and maintained on file for 3 years plus the current year unless an audit is actively being done. Local rules may require records to be maintained longer. Here's the Maine contact information for the Maine Human Rights Commission. Here's the USDA contact information. Steve Miliano is currently the Civil Rights Director for the Northeast Regional Office for Food and Nutrition Services at USDA. We have several resources on civil rights, including our Department of Education Civil Rights page, a link to the civil rights laws, regulations, executive orders, and related other guidance, the USDA Program Discrimination Complaint Procedure, and the Human Rights Commission intake form, which is the Maine state agency that oversees Maine human rights complaints, complaints of discrimination, excuse me. If you have any questions, you can contact the Child Nutrition Program, reach out to me, Adrienne Ackroyd. You can reach me at 207-592-1722 or email me at adrienne.ackroyd@maine.gov. Thank you for joining us today for the 2023 Civil Rights Training. I hope that you have a great day, and please don't hesitate to reach out.